My name is Natalia, as you know, and I'm very pleased to have Novation Consulting's Elizabeth de Stadler with me today. She's ASATA's legal counsel. So you will have received about a week ago a really nifty document on refunds and cancellations that Elizabeth and her team have put together. I know that refunds and cancellations have been a point of pain for many of you in travel. Today's webinar, though, I must just be clear, is not going to deal with which suppliers have specific refund and cancellation policies, how we feel about them, and what to do about them. What I can say is that ASATA is lobbying on your behalf in the background to get you some clarity and to get you some relief. We cannot respond to the specific questions around refunds and cancellations, though, so I ask for your patience and I thank you for understanding. To provide you with some assistance, however, we have put together this step-by-step guide, which is available on the ASATA coronavirus website, with a few really handy templates that will help you to correspond with your customers and with suppliers. So our focus today is going to be to take you through this document and how to use it to its best effect. Before we kick off, I just want to point out that you can ask questions throughout the session. All you need to do is click on the Q&A folder in the bottom of your screen. You type your question, that comes through to me, and Elizabeth and I will discuss them at a later stage. Again, just to reiterate, we cannot deal with specific refund and cancellation issues. This guideline document is there to empower you to respond on your own behalf to customers and to suppliers. We're aware of all of these issues that you're experiencing. We understand the pain, and we are lobbying on your behalf. You can also chat to your fellow attendees if you want to reach out to them. The chat bubble is also at the bottom of your screen, and perhaps you can just type in where you're actually dialing in from today, just as a start, just to greet us. We are also recording the webinar, and we will make the webinar available on the ASATA COVID-19 site alongside the document that we're going to take you through. So with that in mind, I'm going to switch my video off so that you don't have to stare at my mug. And I'm going to hand over to Elizabeth, and she's going to take us through the cancellation guide. Elizabeth, all over to you.
Cool. Natalia, are you going to share the document, or should I share my screen?
If you wouldn't mind sharing your screen, that would be great.
I don't mind at all. Okay, as Natalia mentioned, my name is Elizabeth. I am General Counsel or General Legal Advisor to ASATA, and we have behind the scenes been providing some general legal support to members in this incredibly difficult and complicated time. Maybe before I share the document with you, just a little bit of background. So obviously, we find ourselves in this very unprecedented situation where we have basically every single passenger or traveler cancelling their bookings all at the same time. And one of the things that have been very, very frustrating, I think, to all involved is that no law was ever written to cater for this particular eventuality. So you will find that throughout this session, from time to time, I will say things like the legal position is unclear, or we don't really know how this is supposed to work, but we are trying to figure it out. So my advice to you also, because your businesses tend to be very different, is to take this cancellations and refunds guide as just that. It is a guide. The next step for you would be to take it and to adapt it as you wish, in the form of sort of an internal policy or a guideline to your employees. And at that point, I would always advise people to take some legal advice, as obviously I wrote this to be sort of a one-size-fits-all, and obviously there might be specific things that apply to your business. Okay.
Elizabeth, I can share my screen with you if you like.
Yes, please.
Okay, sharing screen, and let me know if you can see it.
Yes, I can see it.
Okay, is it the one, the cancellations and refunds?
Yes, perfect.
And
perfect.
You can see it clearly?
Yes.
Great stuff. All right, off you go.
As Natalia mentioned, you will find this on the COVID-19 dedicated microsite that ASATA created. It's called the Cancellations and Refunds Step-by-Step Guide. If I'm not much mistaken, you were given it as part of the invite to this webinar as well. Right, so as promised, things get complicated right off the bat. So there are a couple of variables that will have an impact on what rights the consumer has under these circumstances. So firstly, one of the things that we have to think about is this particular client a consumer or not? If they are a consumer, and that is if they are an individual or a very small company with a turnover of below 2 million rand, then the Consumer Protection Act applies to them. And that obviously determines then the rights that they have. The reason for the cancellation is also relevant. So some people started cancelling their travel plans well before there were travel bans, completely understandably, but it does make a difference in what their rights are. So if there was a travel ban, that's one situation, or where a client was sick, but where clients were just getting too nervous to travel, the slightly different rules apply. Then obviously, there might be some different rules that apply depending on whether the travel service provider is in South Africa or not. So if we are dealing with a travel service provider, so a hotel or an airline that has no South African footprint or sitting overseas, other laws might apply instead of the Consumer Protection Act. And then there are always the terms and conditions that you use that might have particular things in them that changes the legal position. So complicated. Because complexity is no good in a crisis, we've tried to keep this particular guide simple and very practical. This is more about managing your complaints than it is about having a legal argument with your clients or your consumers, because that very rarely leads to a good outcome in any event. Right, so when you scroll down in the document, you will see that we're going to do a step-by-step, we're going through it step by step. And the first step, as I said earlier, is to create a policy for yourself on what your approach to cancellations will be during the pandemic. Some of you have already done so. Those of you who haven't, I really encourage you to think through this process and then to advise your consultants very, very explicitly as to what to do and when, because consistency is going to be very, very important. So firstly, step one, your client informs you that they want to cancel. Now we get to ask the question, is this an individual or a small organization? If they are an individual or small organization, they'll be covered by the Consumer Protection Act. Now, the Consumer Protection Act was one of those pieces of legislation that was never written with this scenario where everybody cancels their travel all at once in mind. And the main sort of ombud who is in charge of consumer rights in this country is called the Consumer Goods and Services Ombud. And she has actually done a great job of issuing press releases about what their position is in relation to the Consumer Protection Act. And more or less what she has said is this. Obviously, if travel has become impossible, right? So if there is a travel ban or a particular passenger can't travel because they have fallen ill, then what she has urged consumers to do is to be reasonable, so to accept vouchers or replacements whenever possible or reasonable. But she has also said that in principle they are entitled to a refund if they insist on it. Now, Natalia mentioned that we are working behind the scenes to advocate on your behalf, because obviously what has been happening is that the airlines and some of the other travel service providers are refusing to pay a refund to you guys, to the travel agents. And we know they are doing that to preserve their own cash flow, and to a degree that I suppose is understandable, but it does put us in a very, very difficult position. And so that is an example of some lobbying that is being done by ASATA on your behalf, because as you would have seen in other countries, what they have done is they have temporarily suspended the consumer's right to a refund and have instituted voucher systems. So in other words, temporarily forcing customers to accept vouchers when normally they would want to cash out. And that is to protect all of these industries that are involved, both travel agents as well as travel service providers. Right. So obviously your first step is to contact the travel service provider and find out what their current policies for cancellations and refunds are. Here we've created a template, and Natalia, you don't need to scroll to it, but it is template A, in which you, in very clear terms, explain the consumer's rights to them. So in other words, this is where we say to them what the travel service provider has told us, right? So if the travel service provider has provided for a voucher, and let's say that voucher is valid until March 2021.
Oops, I think Elizabeth might have disappeared. Elizabeth. There she is.
Have you lost me?
Well, we lost you for a sec.
Okay, so maybe if I just backtrack a little, the key to success in template A is to very clearly explain what the travel service provider has come back with by way of cancellation or refund for your customer. And the one thing that I've noticed some agents doing, which is not a good idea, is we tend to use the sort of jargon and terminology that we are used to when we speak to consumers. So for instance, referring to chargebacks, etc. They don't necessarily know what that is. And because they are already quite frustrated and anxious, that will undoubtedly make the situation worse. So please try and put yourself in their shoes and explain their options to them without using travel sector jargon, even though that might feel natural to you. If the client is a large organization, in other words, we're not dealing with a consumer, then they are not protected by the Consumer Protection Act. And then the client's rights will be determined by a combination of your contract with them and the policies and rules of the travel service provider specifically. The template, and there is a second template for this, is not altogether that different from template B, but again, it is about explaining the current policies for cancellations and refunds in as clear terms as possible to your client. In this particular scenario, it would normally be a corporate client. Right, so now we get to what you have done essentially is you've said this is what the travel service provider has offered you at the moment. Let's stick with airlines. And say, well, what 9 times out of 10 is happening at the moment is that the airlines are offering a voucher. And that voucher might be valid for a certain amount of time. It might allow them to substitute travelers. It might not, but be that as it may, you've offered this to them. At this point, what has been happening quite frequently is that some clients have been insisting on refunds for various reasons. Now, the difficulty, again, that agents are being faced with is some of the travel service providers are no longer even processing applications for refunds. So obviously, if they are still processing applications for refunds, at this point, you should apply on behalf of your client. But if they are no longer even processing the applications for refunds, you should communicate this clearly to the client. And this is not necessarily about pointing fingers. It's just about explaining a factual scenario to them. This is what is happening. The advice at the moment, and this again, you must tailor this to whatever you think is best, is what I would advise someone, if I were in your shoes, is to accept one of the alternatives under protest, and that they then lodge a complaint with the Consumer Goods and Services Ombudsman against the travel service provider. Right, so we have provided template C for this purpose. You will see we try to communicate with empathy, advise them what the factual scenario is, and tell them where they can go and make a complaint against the travel service provider. Now comes step 3. The first one is, at this point, few and far in between. You may receive a refund, right? Now, a lot of people have been asking questions about whether you need to pass that refund on to the client. If a travel service provider refunds you, you have to refund the client. Okay, so that is the first principle. But having said that, because you made that initial booking, you have done your job. So obviously your fee for managing the booking, if that is what they agreed to with you, can still be charged, because that is what you have been doing. You have been managing their booking for them. The far more likely scenario is that the travel service provider refuses to give a refund, right? And what happens usually after this, again, is you should advise the client that the refund has been refused, and then you can advise them to accept one of the alternatives, again under protest, or lodge a complaint with the Consumer Goods and Services Ombudsman. We have also catered for the possibility, because we have seen some of this happening, is where some clients, this is usually where I make some disparaging remarks about lawyers. Some of your clients will be lawyers or will be friends with lawyers, and all of a sudden you will receive a formal letter of demand from your client or your client's lawyers. So here we have also provided you with a fourth template, which is a response to a formal letter of demand. We say it's a letter of demand. It's basically where you get threatened with legal action if you don't refund. Here again, you must make a decision in terms of your usual approach to customer services. Right, so sometimes when we see that a customer is becoming extremely unhappy, we will offer a refund, even though technically speaking, you know, we are meeting the client halfway, or we are scared that this client might go to social media and we want to manage our reputation, etc. But in the event that you are not in a position where you can refund this particular client, we've given a formal response for a template for you in the form of template D. Right. So that's basically the entire sort of life cycle of what we are seeing currently with interactions between travel agents and their clients. There's obviously a little bit of a deviation that can happen due to payments being made with a card, right? So Visa and MasterCard have issued rules and have issued statements on these rules, and I urge you guys to go and read these rules, because if you don't follow them, there can be a suspension of payments. But basically what they have said, regardless of what the scenario is that you must resolve your disputes first before you lodge an application for a reversal of the charges. They have been monitoring the requests or disputes that have been logged, and if they see that there is a very high frequency of disputes being logged, apparently they will flag that account, and it can lead to some nasty consequences. So just be aware that you can't use the charge reversal of charges as a way to get money back before you have first resolved a specific dispute with a travel service provider. Right. So what I've mentioned is, obviously we can't prescribe to you guys what your commercial terms must be. So we advise you to record this in a cancellations policy, and the function of this is just to make sure that your internal legal advisors are happy with the approach that you are taking, but to make sure that you are consistent. Inconsistency here can lead to a lot of additional trouble. So we urge you to work out the step-by-step process, and using the templates if you can, and that we also urge you to provide some training on these processes for your consultants. And that basically in a nutshell is this document.
Thank you, Elizabeth. And sorry, guys, I know there was some background noise, and I know you guys all understand that because you're also working from home. And if it makes you feel better, I have a pet rooster, so I've got to lock him outside. Unfortunately, Elizabeth can't lock her children outside, although I'm sure some want to.
They're being exceptionally loud. This is despite the fact, at least they're not being rude. We've had some very interesting board meetings.
I'm fairly sure. So apologies once again for the background noise.
Yes, sorry guys.
Our new normal, I'm afraid, at least
yes.
until we are out of lockdown. And there were some really good nuggets in there, Elizabeth. And as you said right at the start, we have to be as general as possible because it's impossible for us to get specific. So I do note that some of the questions that we have received from our attendees are very much focused around specific issues that you might have with regards to certain suppliers. And just to reiterate, we cannot deal with those specific questions around cancellations and refunds that pertain to specific suppliers, unfortunately. But what we can do is run through some of your questions that are general. So, Elizabeth, sure. If you wouldn't mind, I'm going to put you a bit on the spot and ask you for the Q&As that we've got here. please do go onto the ASATA coronavirus website. It's coronavirus.asata.co.za. That's coronavirus.asata.co.za. You will see this document under our ASATA resources section, which we are populating on an ongoing basis with resources to help you do your role better. Anything that we find, literally, we throw up onto that website and we update it on a daily basis. On this particular document, you will see that there are the template letters that Elizabeth is referring to, and these can be downloaded. So you can literally click here for this template to open as a standalone document. You can copy it and you can amend it and send it out. This document really is very valuable, and I must say immense thanks to Elizabeth's team for putting it together, because I can see it was an absolute monster to do. So if you have any questions, please feel free to forward that through on your Q&A right at the bottom of your screen, or you can also throw it into the chat if you wish. So let's get to it, Elizabeth. Just to be clear, even if the individual's assets are more than, I'm assuming, 2 million Rand, then he or she will still be regarded as an individual. Am I correct?
Right. So yes, if it is, this reminds me of we once did a survey to understand what people understood under the term natural person, and someone wrote back, it's a person who does not wear makeup. The Consumer Protection Act deals with this concept of natural people. That's basically lawyers speak for individuals. The minute an individual has made and paid for a booking, they will be covered by the Consumer Protection Act. And then the Consumer Protection Act will protect small corporates. So in other words, businesses with a turnover or a net asset value of less than 2 million Rand. What I do want to say, and I picked up that there's also a question, what about Namibia? Obviously, Namibia has got its own laws. Last time I checked, there's no equivalent to the Consumer Protection Act. Something that I would urge you to do is to apply the sort of style of communication and the approach that we've taken to your corporate clients as well. I think that, it is good to manage complaints in this way, regardless of the size of the consumer, size of the client, but it is relevant whether the CPA applies or not. So your bigger clients over 2 million will not necessarily have the absolute right to a refund in the same way that an individual will have.
Okay, and that's that whole argument around juristic persons as well, and what the difference is between a juristic person and an individual, etc., etc. So there are portions of the Act that are still applicable to a juristic person of over 2 million Rand. Is that correct? Of
under 2 million. So the Act applies to individuals and small businesses. And small business is defined as someone who has an asset value or a turnover of less than 2 million. Yeah.
This is an interesting question, Elizabeth, perhaps one that you can field for me. Can the client lodge a complaint at CPA if the, let's just say any supplier, not just an airline, is an international supplier?
So unfortunately, the answer there is it will depend on the terms and conditions. And there's a piece of legislation called the Electronic Communications and Transactions Act. If the airline, even if it's an international airline, if they are trading out of South Africa, so if they have a South African address, then South African law would normally apply. If it is an international airline, the terms and conditions will usually specify where the contract has been concluded. If everybody involved is under the impression that European law applies, for instance, I wouldn't argue with them, because actually that's better for your client. The European directives are quite strong in this regard. But so in general, if they've got a local address, then the CPA will apply. If they are international, then it will depend on what the T's and C's say. And usually it will say that the law of the country where the airline has its hub will apply.
Right.
Then the CPA doesn't apply.
Right. If you have any questions, again, Q&A folder at the bottom of your screen. Zane has an interesting one. Usually we sell a package to clients. So in some instances, some hotels, airlines have refunded, but some have not. So in one package, we might have two different hotels. Refund from one. How do we refund the client if it's a package? Great question, Zane.
Yeah, I hate that question. It's very difficult because obviously also you are often under a duty of confidentiality. You're not supposed to disclose the prices. And so, if you say, well, this one has refunded, this one is not refunded, you might inadvertently disclose the prices that you have received for your package travel. Again, if it's in the European jurisdictions, there are specific laws that apply. Here, what you would be essentially telling the client in the vaguest terms possible is that you have received some cash refunds, others are vouchers, and offer that to them in the sort of vaguest terms. So to say this is a partial refund, that is the best we can come up with at the moment, because that hasn't been adequately resolved in South African law in the same way as European law.
Shakila asks, how would you suggest we respond to a client if they have already gone to the CPA and listed the travel agent as the supplier and not the airline? And I know that I get a lot of emails actually directly from consumers who don't understand that the travel agent has not got the refund, essentially. So let's say it's gone directly to the CPA. What recourse would the travel agent have, would you say?
Yeah, so how that would work is if they go to the Consumer Goods and Services Ombud, is that they, and they haven't first tried to resolve it with you, is that they essentially, maybe let's take a step back and explain how this works. So the Consumer Goods and Services Ombud, they're not like a court. They can't make binding decisions. In other words, if they decide you must refund, you can still say, no, I don't agree. And then the case is supposed to go to the National Consumer Commission. So the Consumer Goods and Services Ombud essentially functions as a mediation service. So by bypassing you and going directly to the CGSO, the matter will still come back to you. The CGSO will allow you to have your say. Now, at the very beginning of our document, we included a link to the media statement from the CGSO. And what you can see from that statement, which I find very encouraging, is that she understands that we are in absolutely exceptional circumstances and that it is really important for consumers to be reasonable so that we can basically still exist at the other end of at the other side of this as suppliers, right? So what I would do if someone has taken a travel agent directly to the CGSO is to explain to her that you have not received a refund from the travel service provider. I hope that none of you have had a contrary experience, but certainly my impression from what we have heard from them is that they will take that kind of thing into account, because in those circumstances, I would say it's patently unreasonable to expect of the travel agent to take the fall, for a travel service provider who isn't paying the refunds. Again, ASATA has directed various letters on behalf of travel agents to say to government that this is what is going on and that we are being put on the spot. But it is certainly possible that a client might take you directly to the CGSO, in which case I would emphasize to them that you have not been paid the refund. Obviously, for those of you who have been refunded, that refund should flow through to the traveler. That is the one instance in which I can imagine she will make a finding against you.
Okay, again, so if you have any questions, please feel free to send those through to the Q&A. We do have quite a few questions that have come through on specifics, which I'm afraid that we're really not able to answer, specifically with regards to certain suppliers and instances that you have specifically with a supplier. So Claude's actually asked, is this determined by who paid for the ticket? So a corporate who pays and is a large business, then they cannot use the CPA. So that is a good question. It is defined by who paid.
Yes, it's about who paid the consideration, as they put it. Yeah. So even though the traveler will always be an individual, the payer might be a corporate. So basically, I mean, how we understand the difference between business travel, you will have that added complexity where the client might be a corporate booking on behalf of an individual, not an individual booking for themselves.
Vivian says, are we legally entitled to charge a refund fee for processing refunds over and above the original service fee?
Okay, so there are a lot of contradictory legal advice out there about this. And here, that is a very good example of where it will depend why the booking is being cancelled. If the booking is just being cancelled for reasons unconnected to a travel ban, right? So in other words, the flight is still possible, right? Then there is a cancellation fee that can be charged. If the travel has become impossible, in other words, there's a ban, right? Then it's a different part of the CPA that applies. It's section 47 of the Act. We do set this out in the beginning of the step-by-step guide, as well as towards the end, so you can ask, you know which sections to quote at your in-house legal advisors or external lawyers. Section 47 does not make provision for a cancellation charge. So earlier I said, let's say you do get a refund. Do you have to refund your fees? Right? So this will depend a little bit about what your terms and conditions say. If your fee was for arranging the booking and managing it, you've performed that service, and so you are still entitled to your fee. You cannot, however, charge a fee that you didn't agree with the client. You can't, and that agreement was reached when they made the booking. So you can't add new fees unilaterally to the booking. But yeah, that's basically, so if there is a travel ban, then you can't charge a cancellation penalty on the particular airfare or whatever the case may be. If it is a cancellation, but the flight was still possible or the accommodation was still possible, we're just dealing with a very nervous passenger or traveler. Whilst that is understandable, there we are entitled to charge a reasonable cancellation penalty. And when it comes to your fees, you can charge what you agreed for your services, and that agreement was reached when the booking was made. You can't add new COVID-19 fees.
So that is the difference between disinclination to travel and inability to travel as a result of a force majeure type scenario where it's completely out of your control. And
speaking French now.
I know. And I guess, I'm thinking now, while everybody's kind of up in the air and we don't really know, we know we're probably going to be out of lockdown fairly soon, but we don't know the scenario in September, for example. So, you have a customer who is disinclined to travel now for their September business trip or their September holiday. Could you charge a cancellation fee? Because at this stage, it's disinclination to travel, isn't it?
Yes. So, we don't have a crystal ball. We don't know what's going to be the case by September. So we can only, force majeure will apply for the duration of the lockdown, which, as far as we know, is until the end of this month. So anybody who's cancelling a trip that is further in advance than that it's disinclination or nervousness, which is understandable. So we need to act with empathy, obviously, but that's not. That is not a instance of force majeure yet. And so they don't have the kind of absolute rights that the CPA gives them in that instance. And you charge a cancellation penalty.
Natasha has asked, are clients not allowed to put a claim through to their credit card in order to get their money back from the airline? So you do address in this document a section around credit card charges, etc. Do you want to just unpack that a little bit more for Natasha?
Yes. So basically, what is happening is people are doing chargebacks in instances where the airline has refused to give them a refund. And what Visa and MasterCard has basically said in layman's terms is, sorry, we're out. We're not here to resolve your disputes with airlines. You must resolve that dispute first, and then once you know that there will be a refund, that you can then charge the chargeback, right? So, or process the chargeback. So all they've said is don't lodge the dispute if there is still a dispute between you and basically the travel service provider. That is certainly how I understand it. They have to do that because obviously there are different rules in place in different parts of the world. There's also the issue of perhaps the client has insurance because they booked on the card. So obviously one of the first things that you should advise clients to do, particularly where I see that there are a lot of questions about liquidations. When an airline is being liquidated, that's obviously a very bad situation for everybody involved to be in. And there often what will come to your aid is if you had insurance against airline failure. We all know which specific airline you guys are asking about. And so as you know, towards the end of last year, a lot of the insurers started refusing to insure that airline against failure. So their consumers are in a very bad situation because now we're in a queue along with the employees and all of the other various creditors of that airline. Waiting in line for money, and we know that there is very little to go around. But so usually I would also urge you to, travelers are often not aware of the insurance that they may have taken out, sometimes accidentally. So it might help them where airlines are failing.
Elizabeth, let's talk a little bit about commissions. So we've had a few questions
Yes.
around, are we allowed to keep our commission as we earned that when the booking was made, or do we need to credit the commission to the client that has been received from the supplier? What are your thoughts around commissions?
So my view on the commissions has always been that it was earned when the booking was made, right? Because you did your job. And some of you, would have styled it as a commission. Others, it's a straight up fee. So, that fee was earned when you made the booking. Again, I have to caution that some of your customers might not see it that way. They want all of their money back, partly, because they might not have been paying attention when the booking was made as to how much they were paying you. How I would explain that to a client is that your job was to make the booking, and you did that. You also helped manage the booking, and so those fees, as my quite firm view, is that those fees were earned already. That service was delivered.
So Rudolph has put a question on the chat, not on the Q&A, but it is a very interesting question around this chargeback scenario. If an airline is in liquidation, can we then do a chargeback for non-delivery of service if paid on a credit card? Would you be able to answer that?
So as far as how I understand that is that would not be processed as a chargeback. So again, that's where airline failure insurance will come in, which would normally be with credit card transactions. But I will admit here that I am not 100% sure. So the best would be there to contact the particular service provider, Visa, or the card issuer.
Right. Just going through lots of questions here that are very specific around this idea of international suppliers, and are they bound by the Consumer Protection Act, and what recourse do we have as a local travel agent intermediary when your supplier is an international supplier? What recourse do you have?
Very difficult. I mean, and that is nervous laughter. I mean, we are all in an incredibly difficult situation when they don't have a South African footprint. Even just the question of whether the law, whether the CPA applies or not, is not an easy question, because it depends on a very technical aspect of the terms and conditions. So where the offer was made and accepted. Quite often, South African law will apply. So my advice to everybody has been, regardless of whether you think the Consumer Protection Act applies or not, you can encourage them to lodge a complaint against that particular service provider with the Consumer Goods and Services Ombudsman. As I said earlier, ASATA has directed letters at the Department of Trade and Industry, the National Consumer Commission, basically everybody with an inbox, because we are all really, hungry for some certainty here, and what some of the other governments have done, which I think did a lot to just take the absolute pressure off travel agents and everybody in the travel supply chain, is to say these are extraordinary circumstances. Let's just all agree that we will issue, that we all agree to a voucher system, because we acknowledge that extraordinary circumstances warrant the suspension of consumer rights, and we have made all of those options available to government, and we will continue to lobby on your behalf just to get some certainty here, because obviously it is an untenable situation.
So, to reiterate what you said earlier, you cannot charge a fee if that hasn't been agreed upon prior with your consumer or with your customer, essentially. But Gail has asked even though you can't add fees that are not agreed upon, can you charge a reasonable administration fee to cover expenses? Because now, and I'm conscious of this, travel agents have been working their butts off over the last 2 months to reaccommodate people, get them home, etc., without actually earning a dime for this.
Yes.
Is there no recourse for them to charge some administration fee, at least, to cover their expenses?
So again, if it is an inability to travel, so there's a travel ban, the Consumer Protection Act does not make any allowances for a cancellation penalty to be deducted. If it is because the client is reluctant to travel, so Natalia, your September example is a good one, right? So they either cancel before the travel ban, or they're canceling way in advance because they're just nervous about what the situation is going to be. That is an entirely different proposition. Then the Consumer Protection Act does allow for a reasonable cancellation penalty. How the Consumer Goods and Services Ombudsman interprets what is reasonable indeed is connected to your cost, right? So that is what she refers to as an administration fee. Usually how people calculate that cost is, for instance, by looking at the time that a particular consultant spent managing the booking, and then that obviously is a function of whatever they get remunerated. That's the sort of hourly cost to company. So if it is just because of a reluctance to travel, it's not because travel is impossible, then there is more room to charge an administrative fee to cover the cost that the cancellation has led to for the travel agent.
Okay, lots of questions here. My goodness. Okay, Anonymous says, what happens with walk-in clients that booked online that we are assisting? Can we charge? Is it fair to charge an administration fee to assist the clients to sort their bookings out? So they tried to do it themselves, and then they learned their lesson, and then they came in and they asked a travel agent to help them. So can we charge them for that? It's a new,
it's a new service. Yeah. See, Natalia, I told you, you're going to be a very good lawyer by the end of all of this.
Happy day, Anonymous.
So obviously, guys, like, if let's say it's either a walk-in, like the scenario that was just mentioned, so you didn't make the initial booking, you're helping someone out. Even if it is a booking that you made and the person has now come back to you, at that moment when they're asking for your assistance, there is nothing that stops you from saying, I am happy to help you, it will cost X amount, and and to charge a fee for that. You just need to agree it with them. What you can't do is start processing the cancellation, and then when it comes time to give them their refund, then deduct an amount for yourself from that refund. That is the behavior that you can't. That's what you can't do. Is you can't say, sure, I'll help you, not be specific about the fact that it's going to cost them something, and then just deduct a fee. If you agree a fee with them to assist them, you're free to do so. And you can then charge that fee. They need to be able to walk away from the fee if they wanted to.
So there are quite a few questions that are indirectly leading to this one question, and that is
yes.
This breakdown of costs. So, does the client actually know how much commission you've earned? Can the client request that they get paid that commission out? The client now wants a breakdown of exactly what those costs are and says that he has a right to know this. Does a client have the right to know exactly how that package is broken down?
So there are rules around, and some of them have been recorded in the ASATA Code of Conduct, which you will also find on the website, around what aspects of the price you must disclose to them. So again, I understand that some of you sell package travel and you are not allowed to disclose the price that you are charged. You are under confidentiality obligations in terms of your agreement with the travel service provider. The rule in general is that they are entitled to price transparency, so they need to know how much they are paying for what. So in other words, how much of this is going towards the actual service and how much of this is actually a commission or a fee. In the case of airlines, for instance, they are entitled to know how much is being paid in taxes. So the general rule, unless there is some kind of confidentiality, duty of confidentiality, which is normally involved in package travel. In other words, I bought a holiday for X amount. They are entitled to know how much is the holiday and how much are you getting as your fee. Some of you are referring to this as a commission. Obviously, there are varying scenarios here. Some people are being clearly being paid commissions, and others are just charging fees, which my understanding is that's the more general arrangement now these days.
So Marie has a great question, and we talk about the fact that we have suppliers who are only offering refunds at the moment and only offering vouchers at the moment and are not allowing for refunds. And
yes,
if you have a traveler who was only traveling on those specific dates because they were going to a wedding or it was someone's birthday or whatever it is, and now of course it's not relevant for them to travel anymore. So they're not going to use the voucher. They're not going to be able to postpone to new dates. That scenario, is the end supplier liable to refund them? I mean, I know the end supplier is liable to refund them according to the Contract Act, but the travel agent is in the middle. So what can the travel agent do?
Okay, so again, the answer, there's a slight difference between whether the person is being affected by a travel ban or whether it's now just sort of general nervousness that makes them not want to travel. So let's assume that it's a travel ban, because that's 90% of the scenarios now. If you can't travel, you were going to go for a wedding or a marathon or a whatever event. I am a party to a scenario like that at the moment. I was going to go for an event. Event gets cancelled. There's now a travel ban as well. I'm not interested in a voucher because I was going for a very specific reason. This was not a holiday that I can take later, etc. So what happens, as you would recall, as I said, well, if there's a ban, what the CGSO, the Consumer Goods and Services Ombudsman, has been saying is, well, customers have to behave reasonably. So if a voucher suits them, they should take it. However, when we're dealing with a trip for a very specific purpose, it was bound to an event or a specific marathon that was going to be on a specific date, then what the CGSO said is then it would not be reasonable to force the consumer to take a voucher, because then it isn't a real alternative, because they won't necessarily be able to use that voucher for the same purposes. So that all goes into that reasonableness weighing up that the Consumer Goods and Services Ombudsman does every time that there is a complaint where it's relating to a travel ban, impossible to travel. When it's just general nervousness, or what did you call it, Natalia?
Disinclination to travel.
Disinclination to travel. Then under the Consumer Protection Act, what a lot of people don't know is that you still have a right to cancel an advance booking, but then you can impose a cancellation penalty. That's the big difference, is when it is a disinclination to travel, they still have a right to cancel and they have a right to a refund, but we can deduct a penalty, and that penalty is usually a function of the cost of processing the cancellation. Or any refund, any discount that they may have gotten as a result of booking far in advance, etc. Many people have different ways of calculating that refund, but it is usually a cost.
Okay. Last question I'm going to field to, and we've got lots of questions I think we can respond to. So what I will do is I will collate all the questions we have received. And I'll run through those that we are able to answer with Elizabeth and commit to sending you guys the answers to them.
Happy to create the FAQ or to supplement the FAQ that we already have.
This is one question I've already asked you, Elizabeth, and that is around the validity date of vouchers. So
yes.
I know that's a bit of a moving target because we have some suppliers giving a year, we have some suppliers giving 3 months. What does the CPA tell us in terms of validity dates for vouchers?
So it's a very controversial part of the CPA, but the short answer is 3 years. So a voucher under South African law has to be valid for 3 years. There's actually been a lot of argument and they've threatened litigation, and particularly the cell phone, the mobile network operators, against that specific provision of the CPA. But it does currently say that vouchers that can be used, in lieu of money to exchange for services has to be valid for 3 years.
But 3 years is a very long time in travel.
It is. It is an exceptionally long time. So this was one of the reasons why, but it was never accredited. Airlines have been saying that they want a code of conduct under the Consumer Protection Act, but that code of conduct has never been accredited. So that's the only way, as far as I'm concerned, for them to change that provision. But that is the National Consumer Commission's view, is that it has to be valid for 3 years.
Okay. On that note, I'd like to thank Elizabeth for braving running a webinar while she didn't have any assistance to help her with her baby. So thank you very much for stepping in and assisting us with that, Elizabeth. And thank you to all of you who have logged on today. I know that the pain is excruciating at the moment, and I'm sorry that we can't wave a magic wand and fix the cancellation issue for you. And we're getting it from consumers, we're getting it from you. I'm so very sorry, but we will help you as much as we can with information. And Elizabeth and I will undertake to go through all these questions and create an FAQ along with the recording. So please, guys, stay safe, stay strong. We can get through this together. And thank you for joining us. Goodbye, everyone. Until the next time. Cheers.